discharge of contract. When two or more parties enter into a contract, each of them has duties or obligations arising from the contract. When a contract is discharged, it is fully terminated. Once a contract is discharged, the contracting parties are free from further obligations under the contract. There is four modes of discharge contract. First is by performance of the contract. Second, by the consent or agreement between parties of the contract. Third, impossibility in performance. And fourth, breach of contract. Contract by performance is the usual mode of discharging a contract. It is when the person to a contract fulfill the obligations increasing under the contract the within the and manner prescribed. The contract will be discharged for performance. For example, if the buyer pays the amount of money he promised to pay, he is free from obligation under the contract. The buyer will be discharged from the contract. Section 38 in bracket 1 of the contract 1950 provides the parties to a contract must either perform their respective promises unless the performance is excused or suspended under this act or any other law. When the parties have performed their contracts by carrying out their promises under the contract, there is a complete discharge of the contract. If only one in the parties has performed his part under the contract, he alone will be discharged from the contract.
Assalamualaikum and a very good day to my lecturer and my fellow friends. So today I will be talking about discharge of contract. When two or more parties enter into the contract, each of them has duty or obligation arising from the contract. Once the contract is discharged, it is actually terminated. The contract parties are free from the further obligation under the contract. There are four modes of the discharge contract, which is by performance of the contract, by consent or agreement between parties of the contract, impossibility in performance, and breach of contract. For contract by performance, it is the usual mode of discharging the contract. It is when the person to a contract fulfills the obligation increasing under the contract within the manner prescribed, and the contract will be discharged the performance. For example, if the buyer pays the amount of money he promised to pay, he is free from the obligation under the contract. The buyer will be discharged from the contract. Section 38, subsection 1 of the contract 1950 provides the party to a contract must either perform their respective promise unless the performance is excused or dispensed under the Act or any other law. When the parties have performed their contract by carrying out their promise under the contract, there is a complete discharge of the contract. If only one in the parties has performed his part under the contract, he alone will be discharged from the contract. For time of performance of the contract is important. Any delay by one party will entitle other parties to free himself from any obligation of the contract. He may choose to make the contract voidable. The contract states that at the time of the performance, parties must perform the contract within the specific time. In section 56, subsection 1 stated, when a party to a contract promised to do a certain thing at or before a specific time, or certain thing at or before a specific time, the contract or so much of it has not been performed, become voidable at the option of the process. If the intention of the parties was that time should be of essential of the contract. The relevant case for this is Sim Choi Pat versus Wong Tet Fui, in which time the parties fail to perform it by stipulated time. The innocent party has right either to resign the contract or to treat it as still subsisting. According 56 subsection 2, if the time is not essential, The contract does not become voidable, but the promise is entitled to compensation for any loss he suffered. This being specified for the performance of the contract. The parties must perform the contract at the place specified. If there is no place specified, the promissory is under the duty to ask the promisee to specify the place of the performance of the contract. Based on Section 50, when the promise is to be performed with the application by the promisee and no place is fixed for the performance of it, it is the duty of the promiser to apply the promise to appoint a reasonable place for the performance of the promise and to perform it at the place. For example, Miss Alia ordered cake from Miss Sarah and should be delivered on a specific day. Miss Sarah must apply to Miss Alia to appoint a reasonable place for the purpose of receiving the cake and must deliver it to her at the place. For performance by whom, the intention of the parties that the contract should be performed by the promiser himself. It must be performed by him personally, particularly when the contract involves skill and expertise. The promiser cannot simply delegate it to someone else. In Section 41, it is appear from the nature of the case that it was the intention of the parties to any contract that any promise contained it in should be performed by the promiser himself. Then it must be performed by himself. For example, I promise to Ayu she will help Ayu with her assignment. So I should be performed in this promise personally. In some situation, the promiser may employ the competent person to perform the contract. The promiser will be personally liable under the contract. For example, I promise Ayu she will give Ayu her book. I may perform this promise either by personally paying the money to Ayu or by causing it to give to Ayu by another. But if that day I could not give Ayu her book back due to some important reason, her representative must perform the promise or employ some proper person to do so. Or performance by third party, if the promise performance from the third party, he cannot enforce it anymore against the promiser. In Section 42, when a promise accepts performance from third party, he cannot enforce it anymore against the promiser. The example for this case can be seen of Haji Nik Ishaq bin Haji Nik Daud versus Nik Zainab binti Nik Jafar, and Ching Su On versus Pushong Realty Sdn Bhd. When the promise has agreed that the third party will perform the contract on the behalf of promiser, the promise cannot sue the promiser if the third party failed to perform the contract. The action will be taken against the third party. For discharge by agreement, contract is created by agreement is to also terminated or discharged by the agreement of all the parties. The agreement to discharge the contract can also be made subsequent to the contract, according to Section 63 and 64. For Section 63, if the parties to a contract agree to substitute a new contract for it or to recite or alter it to the original contract need not to be performed. In Section 64, every promise may disband or remit wholly or in a part the performance of the promise made to him, or may extend the time for such performance, or can accept instead of it any satisfaction which he thinks fits.
Next, let us move on to the remedies for breach of contract. Remedies breach of contract is the parties to a lawful contract that are bound to perform their respective promises. But when one of the parties terminate the contract by refusing to perform his promise, then it will be have committed a breach of contract. Breach of contract is not an unlawful act, but the Contract Act accommodates it. It is quite likely that a person may not keep his promise, but the Act has made provision for remedies for the injured.
Discharge by impossibility. An agreement is void if it includes a promise to perform an impossible task. The following is the reason for this law. The law does not accept what is impossible. The impossibility of anything should not make it mandatory. Impossibility of success will fall into one of two categories according to section 57. For the first is the contract is in itself impossible to be performed. The contract becomes discharged when either one or both parties become aware about the impossibility. In section 57 in bracket 3 state where one person had promised to do something which he knew or with reasonable diligence might have known and which the promisee did not know to be impossible or unlawful, the promiser must make compensation to the promisee for any loss which the promisee sustains through the non-performance of the promise. For the second situation is the contract becomes impossible to be performed after it has been done. Sometimes a contract may be performed at the time it was made, but subsequently something happens which caused the contract to be impossible to be performed. In section 57, in bracket 2, a contract to do an action which after the contract is made becomes impossible or by reason some event which the promiser could not prevent. Unlawful become void when the action become impossible or unlawful. The case that related with discharge by impossibility is Taylor versus Caldwell. A music hall was rented by the plaintiff from the defendant for a series of concerts. However, the hall was accidentally burned down before the date of the concert. It was held that the contract was void due to the frustration. Next is discharge by breach of contract. Breach of contract occurs when a promiser fails to fulfill a commitment or fails to fulfill the obligations imposed by a contract. It happens when a contracting party fails to meet his contractual obligations without lawful excuse or makes it impossible for him to do so by his own actions. Breach of contract may be of two types. For the first is um, actual breach of contract actual breach of contact, and the second is anticipatory breach of contact. So, for the case that related with the discharge by breach of contract is Smith Construction Co. Ltd. versus Fit Kiribati. In this case, it was held that the refusal to issue an architect's certificate as agreed under a contract amounted to a breach of contract because it prevented the contractor from proceeding with the construction of the building. Since time is important in the contract, the party not in default has a choice either repudiating the contract or treating it as subsisting. So, um, the discharge by breach is when the promisor fails to perform um, his obligation, there is a breach of the contract. Okay.
So I would like to talk about rescission of contract, which is if party breach his promise under a contract, the party not in breach has the right to rescind or terminate the contract. Section 40 of the Contract Act provide when a party to a contract has refused to perform or disable himself from performing his promise in its entirety, the promise may put an end at the contract unless he has signified by word or product his acquiescence in its continuance. For the second remedies, which is damage. Damage is most popular types of remedy in the event of breach of contract. Damage is granted to a party as compensation for the damage, loss or injury suffered due to a breach of contract. The purpose is to put the plaintiff so far as the money can do it in the same situation as if the contract has been performed per part, which is B in Robinson v. Herman. The rules relating to damage are provided in section 74 to 76 of the Contract Act. Section 76 states, which is okay. We move to types of damage, which is section 74 set out the types as well as the measure of damage recoverable. So, for example, when a contract has been broken, the party who suffers by the breach is entitled to receive from the party who has broken the contract compensation for any loss or injury, damage caused to him thereby, which naturally arose in the usual course of things from the breach, or which the parties knew when they made the contract, they to be likely to result from the breach of it. Under Section 74, an injured party is entitled to two types of damage, which is A. Damage arising naturally or ordinary damage. These are damage for any loss or damage caused thereby, which naturally arose according to the usual cause of thing resulting from the breach. Illustration F, Section 74, contracts to repair B house in a certain manner and receive payment in advance. Repairs the house but not according to the contract. B is entitled to recover from A the cost of making the repairs conform to the contract. So we move to okay for B, which is special damage for any special loss sustained. It is compensation for any loss or damage caused by the breach of contract, which is known to the person in breach. Special damage must not be to remove, and the person in breach can foresee the losers at the time making the contract. Plaintiff claiming special damage must prove that the other party, which is defendant, knew that the plaintiff loss of profits by the plaintiff if the dependent is in breach of the contract. Okay, so we move to the specific performance, which is an order of the court to the party and for forcing him to carry out the contract according to its terms. It compels the contracting party who is in a breach of the contract to fulfill his obligation under the contract or to perform the contract as agreed. This remedy is given at the discretion of the court as provided under Section 21. Specifically, Act 1950 SRA. The jurisdiction to decree specific performance is discretionary. 4. For the situation where specific performance may be granted, normally this remedy would be granted if damage is not an adequate
remedy for breach. Section 11 of SRA provide the following circumstances under which specific performance may be granted. Okay, for the first is Section 11(1)(a), when the act agreed to be done in the performer wholly or partly of a trust. For illustration, example, holds a certain stock in trust for B. A wrongfully disposes of the stock. The law creates an obligation on A to restore the same quantity of stock to B, and B may enforce a specific performance of his obligation against A. For the second is Section 11(1)(b), when there exists no standard for ascertaining the actual damage caused by the non-performance of the act agreed to be done. For illustration, A agrees to buy and B agrees to sell a picture by a dead painter and two rare china vases. A may compel B specifically to perform this contract, for there is no standard for ascertaining the actual damage which would be caused by its non-performance. For the third is Section 11(1)(c), when the act to be performed is such that pecuniary compensation for its non-performance would not afford adequate relief. Okay, for the illustration C, a contract also in Section 11(2), also have a relevant case, which is Zaibun Sa binti Sheikh Ahmad bin Kumoy and Anor, and the second, Mas Equity Sender Berhad v. Tis Atasha Sender Berhad. In situation where specific performance cannot be granted, in Section 20 of SRA, on the other hand, lays down the following circumstances when a specific performance cannot be granted. For the first, a contract for the non-performance of which a money compensation is an adequate relief. In Yo Leong Sang v. Lucky Park, the court refused to grant specific performance as damage could provide an adequate remedy. For the second is a contract which runs into such a many or numerous details. For the third, a contract which is so dependent on the personal qualification or violation of the parties, such as a contract of employment. In case Lumley v. Wagner, contract to sing at the P theatres for 3 months and promised that she would not sing elsewhere during the time without the piece written permission. Okay, for the fourth, a contract requiring supervision by the court, such as in building contracts. Fifth, a contract that the terms of which the court cannot find with reasonable certainty. A contract which is in the nature revocable, such as contract a partnership of no fixed duration. This contract can be revoked at any time by a party. 7. A contract made by trustee either to lease it for 7 years. He enters into a contract with B to grant a lease of the land for 7 years, with a covenant to renew the lease at the expiry of the term. This contract cannot be specifically enforced. For the 8, a contract made by or on behalf of a corporation or public company created for special purpose or by the promoters of a company which is in excess of its power. For the 9, a contract the performance of which involve the performance of a continuous duty extending over a period longer than 3 years from its date.
Next, I will explain about the injunction. In general, injunction is a court's order to restrain the doing, continuance, or repetition of some wrongful conduct which is against the contract. It is granted at the discretion of the court, and it is also governed by the Specific Relief Act 1950. So there's two types of injunction. The first one is temporary injunction, and the second one is the perpetual injunction. In other words, is permanent injunction. So, the temporary injunction is a The temporary injunction are such as are to continue until specified time or until the further order of the court. They may be granted at any period of a suit and are regulated by the law relating to civil procedure. So the purpose of the temporary injunction is to preserve the status quo pending the resolution of a legal action. The relevant case that we can relate is the American Cinemite Co. versus Ethicon. So, the basic principle in granting an interlocutory injunction requires the court, in such an application, to ask whether there is a serious question to be tried in the sense that a claim is not frivolous or vexatious, and not whether the plaintiff has made a prima facie case. Okay, the next type of injunction is the perpetual injunction, which is permanent injunction. A perpetual injunction can be only granted by the decree made at the hearing and upon the merits of the suit. Defendant is thereby perpetually enjoined from the assertion of a right or from the commission of an act, which would be contrary to the rights of the plaintiff, as we can see in the case of Neo Siu Eng versus Tu Chi Kwong. So basically, in this case, the court granted a perpetual injunction by ordering the defendant, who was a landlord of the plaintiff, to keep all communication pipes in proper repair and to comply with all regulations of the Waterworks Department so that water supply to the premises rented by the plaintiff would not be disconnected. This is the situation where injunction cannot be granted. Contract that cannot be enforced by specific performance could not also be subjected to an injunction. In instance, Section 45F of SRA states that an injunction cannot be granted to prevent the breach of a contract, the performance of which could not be specifically enforced. For example, Section 20, Subsection 1b of SRA provides that the contract of employment which is so dependent on personal service of a person cannot be specifically enforced. Hence, since specific performance cannot be enforced, injunction would not be granted either. However, this is a general rule. This exception is contained in Section 55 of SRA, which provides an exception to the above rules. For example, we can see this case in the Lumley versus Wagner. In this case, an opera singer contracted to sing for L at the theatre for 3 months and promised that she will not sing elsewhere during that period without L's written permission. So, W later agreed to sing for C at the Covent Gardens for a larger payment and abandoned her contract with L. So, after that, L sued W for specific performance. It was held that the court will not enforce a positive contract of a personal service. Therefore, the court did not grant specific performance against W. To order W to sing at L's theatre, however, the court granted injunction restraining W from singing for C at the Covent Gardens. Tak payahlah cakap. Next is quantum merit. Quantum merit is mean as much as he was deserved. It is a claim for reasonable remuneration for work done or service supplied under the contract. In the event of a breach of contract, the claim arises in two kinds of cases. The first one is where one party abandons or refuses to form the contract, and the second one is where work has been performed and accepted under a void of contract. So I will give the example for the case Plancher versus Colburn. In this case, P contracted with C to write a volume of ancient armor for a periodical called the Juvenile Library. For a fee of $100, after P had written part of his work, C abandoned of the periodical. The contract could not therefore be completely performed. And then P sued C. It was held that C had repudiated the contract and P was entitled to treat it is as discharged and recover a quantum merit for the work he had already done. So for the next one, where work has been performed and accepted under a void contract, in this case, I will give example of the cases Craven Ellis versus Canons. There is P was employed as managing director of Canons under a contract with which provide for salary. Unfortunately, the directors who made the appointment contracts were unqualified because they had never obtained the required numbers of shares. So therefore, the contract of appointment was void. P had rendered his service and now sued on quantum merit for a reasonable sum. It was held that P could recover on quantum merit since there being no any valid contract. If there is an existing contract which does not have the details such as the price is not fixed, the seller is entitled to a reasonable price as a quantum merit. Thank you.